versus Miguel Pratt and Leticia Gonzalez.
Afternoon, Your Honor. Robert Eggerson on behalf of the defendant.
Good afternoon, Your Honor. Joseph Basis, appearing on behalf of the plaintiff, Jorge Ortega.
All right. It's non-payment of rent case. And where are we on this case?
There's a counter complaint for affirmative defense and demand. We'd ask that for a jury trial is the available date for your jury call in October.
You answered the counter complaint.
I am in the process of doing that, Your Honor. I was planning on having it before today because I did have in the interim, my son had a baby, so it's been a little like.
Congratulations.
Thank you.
I think we ought all celebrate and just get rid of this case. All right.
See, the last lawyer didn't want to come back. And
Yeah, I know.
didn't want us to come back.
I didn't say I didn't want you to come back. I like things being resolved. Let's do this then. If you're going to answer that, prior to me setting it so that you understand my process,
Okay.
I would set it for a final settlement conference where you guys would come in and we'd try to see if we can hash this out.
Okay.
If we can't hash it out, then it will be set for a final settlement conference and jury selection, which will be Friday and Monday. So right now, what I'm going to give you is a Tuesday date to come back.
Okay, just everybody. Okay.
Will that work?
Yeah, that's fine. That's fine, Your Honor. I would just ask, because they demanded a jury, I'll reiterate my motion for escrow.
Yes, I will order escrow.
Thank you.
Your Honor, I'd like to argue against.
Go ahead.
First of all, the statute, the court rule is clear that you should consider all relevant factors in this. This is a very unique case. Mr. Ortega and Ms. Gonzalez were boyfriend and girlfriend living in this house starting in 2021. They have 3 children together. Those children also live in this house. So effectively, Mr. Ortega is trying to evict his former girlfriend and his 3 children. So that's a factor. The agreement was, the testimony by the defendant will be that in lieu of child support, he was going to let them live in that house. And there is no written lease. They've never paid rent, even though the defendant claims one time they gave him money because he asked for it, that's rent. There is a document that my client prepared when she gave him that money that says, that he didn't sign, but it says this is to help you make the mortgage payment because that's what he said. The final factor in this that you should consider and rule against an escrow is that the plaintiff attempted before this case began to construct the defendant and his 3 children by turning off the electricity. All those factors go toward this issue. And remind the court what I probably don't need to remind the court is that you have equitable powers in making this decision under the RJA statute that pertains to summary proceedings. So for those reasons, and because he's not paying child support, and because he actually owes my client about $25,000 for the use of her credit card, we'd ask you to deny the motion. Thank you.
I don't need a response right away. I will answer this in regard to escrow. If there are claims regarding interference with utilities or constructive evictions or forcible reentry in terms of turning off the electricity, that certainly can be adjudicated. If that's not the circumstance at this point in time, I don't know that I need to take it into account regarding prospective escrow.
It's in the counter complaint.
Right, but I don't need to take that into account as to what they are paying forward. and I say it this way, I say it that way for this reason. Let's say he had, and I'm not saying that he did, because I don't know, but let's say he had turned off electricity for the first 15 days in September. Then certainly if I were setting escrow for that, inclusive of that period, I think you're right. I would include that in my analysis. However, going forward, if that's not the case, it's not it. Your client may be entitled to damages for that, but that wouldn't factor into my escrow determination.
Here's why I think it should, and I'll be brief, and I respect your ruling so far.
Lawyers always say that before they're about to. Go ahead.
That is true. That, and this will be a short.
Yes, yeah, I didn't believe that part.
Under your equitable powers, you have the ability to note his unclean hands. And that's why I bring it up in this context. He has unclean hands. He tried to get former girlfriend and 3 children to move by turning off the power. Thank you.
Okay, and I understand that, and I can certainly, maybe with any division of escrow, I may be able to take that into account, maybe not. The other part that you bring up, which I guess I am so fond of saying, is that if I wanted to be a family court judge, that's what I'd be doing. I do not. All right. And so typically, however, with child support, and I might agree with you, counsel, if there is an agreement with the friend of the court that something else was going to occur in lieu of child support. If that were the case, then I might be in agreement with you, because that was really clearly part of the rental arrangement. I don't, unless there is something, I don't have that.
There is none.
Okay, so I'm not sure that it would be for this court to take that into account, because, and the other reason I think it's inappropriate for this court to take that into account is I would have no way of knowing what the child support would be. So I don't have any basis upon which to say what the consideration would be of the $2,500, I think it is, monthly rent. I wouldn't know. So there would be nothing for me to factor. And I'm not going through that analysis. I do not have a friend at the court to give that to me, and I'm not going to ask for it. Right. So I hear you, but I don't think it's appropriate for this court to take all of those things into consideration that you've raised for that reason. Is it? Go ahead, Cal.
I just need to respond. Obviously we dispute virtually everything Mr. Grayson said, but I have a text message from their client to my client saying rent starting in March 1 for $2,500. She paid rent in March. She paid rent in April. She paid rent in May. She paid a partial in June. The reason why we're here today is because she stopped paying rent. So already we understand that is a strategy to ask for a jury trial. But as the counter to that is we were entitled to, she should put the same amount of rent into escrow to make sure that this is just not another delay tactic for not paying. That's what it means. There is, and I would agree with you, Your Honor, and I don't think it's inappropriate for this child support. There is no agreement. Mr. Grizzly even acknowledged there is no agreement. And I'm not sure you even have jurisdiction. That should be decided. If she wanted to claim there's a child support issue, bring it up to the front of the court. That's not here. That's not the agreement. And she knows that. She paid rent. She just stopped paying rent. She has her right to ask for a jury demand, but we have the right to get that money put into escrow. So this is just another delay tactic. And we can show evidence that she's made payment. I can show you the text message that she gave.
No, I understand, and maybe that buttresses what the court's position is, but I don't know that I need to see that. The court can arrive at that decision without it. I'm gonna order escrow, monthly rent being about $2,500. I'm gonna order escrow be paid to the court in the amount of $833. That will be the prorated amount for the month of September. And then $2,500 per month beginning October and forward. That needs to be paid within 7 days of the date that rent is ordinarily due. The first payment will be due by the 27th, the $833 by the 27th, and then the other within 7 days of the date that it's ordinarily due. And counsel, I'm sure you can explain to your clients if the result of what would happen if they're failure to place that into court escrow.
Yes, Your Honor, just so I understand, 833 is due by September 27, and then 2,500 is due by October 7.
Yes, within the date that, yes, 7 days of the date that it's ordinarily due.
Do I need to prepare an order to that effect or?
Yes, why don't you, since
Okay.
I've written it in the file, so I know what I've ordered, because it's consistent, but if you prepare a written order, that would be great. All right, so the first step, and since where we are, I won't await the counterclaim to set
Fair enough.
the final settlement conference. I will assume that the answer is coming into the counterclaim. And if any issues arise, we can address that. I have what date?
Yeah.
April 9. All right. So I will adjourn this, or I will set this for final settlement conference, October 15th, 2024, 9 a.m.
Do that by Zoom.
No, that has to be in person. The final settlement conferences are in person. So that council's aware, so that there are no surprises. This court selects juries every other month. So October would be the selection. So I will have to make a choice if it doesn't resolve on the 15th, that you would be selecting a jury on October 21st. You may get another date in between that you don't have to pay attention to. I waive that date, but you may be selecting a jury October 21st with, and I'll give you a date that it would happen at that time. Now, having said that, because this is a civil matter, yet a summary proceeding, you take the back seat to my criminal cases.
Sure.
All right. So a lot of that scheduling part is going to depend on how many criminal cases I have going.
We will know that obviously about 15th when we come in, perhaps, maybe not.
I may have an idea, but I can't,
That's fair.
sometimes.
Your Honor, if I may,
Yes.
I just want to bring it up. I mean, one of their defenses or their counterclaims is this whole child support issue. Do we need to, I mean, to me, I think you've already sort of made a ruling. Do we need to address it again? Because
I
otherwise-
sort of made a.
well, I don't mean to be.
No, I know what you're saying.
I'm just trying to say, because that seems to be a big part of their defense. And I think he's admitted that there is no agreement. And I think Your Honor has said that there is nothing in writing.
Can I just,
I did not admit that. I said there was an agreement that included child support. You said it's not part of.
it's not part, correct. The only thing that counsel agreed to it or acknowledged to the court was that there was not an agreement with the friend of the court.
Right. Maybe I misspoke. That's what I thought I was saying, that there was no agreement with the friend of the court, which is what you said. If that was the case, then you may consider it.
Correct, but that would be consideration of what rent, that was in reference to determining escrow. As to the ultimate picture, I don't know. I mean, I just don't think, as I was saying to counsel, I don't think I should be taking that into consideration for escrow. Ultimately, in the case, it might be there. I don't know. So yes, you're gonna have to deal with
Okay,
it.
that's, I just wanted to make sure I understood.
And you may be right that any. You know, and I'd have to look at that as, it wouldn't be an issue as to whether or not. I don't know. I mean, you raised kind of the jurisdictional issue, and I don't know where I would fall on that, to be honest with you. I mean, because I just don't know. And that it's hurting my head to think. I'm just gonna be honest. All right, so folks, well, and so we'll have the 15th, and then we can move forward from there in terms of that.
Assuming the parties have to be there.
Absolutely. How old are the children?
Go ahead.
16, 13, and 12.
All right. Okay, so folks. When you come down to, and I don't think either one of you have had a final settlement before me before. I sometimes look at things very practically as to how to get things resolved. I think, just as a thought for all parties' consideration, is that sometimes, just put it how my mother used to say it, sometimes the big people have to put what they've got aside to care about the little people. So I think, and I'm not pointing fingers anywhere because I don't know everything, but I think the parties need to think about that. From the standpoint, and just by way of example, if you're the father of those 3 kids, and outside of her, and I don't mean to refer to you negatively that way, but I'm just saying, you've got an obligation to them to make sure they're protected. And that may mean I sometimes just have to eat some money because the reality with kids, you're doing that the rest of your life. So I say that to you. To you, sometimes I might have to pay something so that my kids have a place to stay. I don't know where the answer is, but I think if you had 3 of them, you guys can figure it out. So I think you all ought to chew on that a while. You got 2 good lawyers. They can help you when you get stuck. We'll see you on the 15th. Thank you. Watch those 2. Council, hold for a moment. Council, hold for a moment. Council, on that last matter approach, please. Yes.
Oh, sorry.
Watch those.